where somebody enters into a Hindu temple, they try to give it a shape of a mosque and they start offering namaz there. That Sonia Gandhi is an outsider. Her real name is Antonio Maino, and this practice of marrying Section 5C of the Indian Citizenship Act must be declared as unconstitutional. And if a Hindu has more than one marriage, it is punishable under Section 494 of the IPC. But a Mohammedan or a Muslim, he does not get punished under Section 494 of the IPC. And a person can get salvation or nirvana only by being in Kashi. The temple which was existing there was partially demolished and it was converted into a mosque, which is known as Gyanvapi Mosque. Whether it was built by Aurangzeb or whether this structure dates back to Aurangzeb, very good question. Let me answer it in a little detail. Lord Shiva had self-incarnated himself in Swayambhu form, and from there they will go to Shivlok. Okay. So that's the place of Mukti. Okay. Now the Anjuman Intizamiya is saying that it is not a Shivlingam, it's a fountain. Okay. So it's a wrong order, it's an erroneous order. When ASI survey will be conducted, nobody in this world, if people are allowed to go there and visit that spot, nobody in this world can say it's a mosque. No. The pillars on which the so-called mosque is standing are the pillars of Hindu temple. From 1976 till this very day, while I am talking to you, every day, every minute, he is working for the cause of Sanatanis. That it's time for us to unite. It's time for us to realize our issues. It's time for us to fight our civilizational battle through constitutional modes and mediums. And it's time for us to come out of this hoax of the word of secularism which has been created by our rulers in the past.
Namaste and a very warm welcome to the Nationalist Madrasi. This is Intellectual Exchange with me, Sri Dharma Raghavan. In today's episode of the Intellectual Exchange, we are joined by an esteemed special guest. He is none other than Vishnu Shankar Jain. He is a Supreme Court advocate. He is also the Hindu side petitioner of the Gyanvapi issue, which is an ongoing issue in the Varanasi district. He and his father has been fighting very long legal battle in many of the cases like Ram Janmabhoomi and Krishna Janmabhoomi, and now he is taking forward this case of Gyanvapi as well. In Hindu religion, we usually say as Vishnu saves the religion. Here, both Hari Shankar and Vishnu Shankar have been saving the religion for a very long time, and they have been fighting the legal battles of all these issues as well. Thank you so much for joining our podcast, and it is a pleasure hosting you, sir. Sir, give us a brief introduction about what is this ongoing Gyanvapi issue, because ASI has ordered a survey and there is a more controversy which is going on day by day. We came to know that many things are hidden over there as well. So what is this Gyanvapi issue all about, sir?
See, from time immemorial, we have a very firm belief and faith and astha at the point in question where the so-called mosque is being created or constructed. The plot number which is where the mosque is situated as of now, the so-called alleged mosque where it is situated is called Khasra number 9130. In Khasra number 9130, we believe and we have a strong faith and astha that Lord Shiva had incarnated at the same very place in Swayambhu form from time immemorial. The Itihas of Kashi needs no, I need not dwell into Itihas of Kashi much, but so far as Shiv Puran is concerned, Iskan Puran is concerned, Shiv Mahatma is concerned, in all these Purans, Veds and Shastra, it is mentioned that this 5-coast area is known as Avimukta Kshetra, and a person can get salvation or nirvana only by being in Kashi, and only by if that entire 5-coast area is very sacred to us. So it has so happened that this so-called temple was demolished many a times, and lastly it was partially demolished in 1669 by Aurangzeb, and the temple which was existing there was partially demolished and it was converted into a mosque, which is known as Gyanvapi Mosque. Now I may ask a question to myself, that there is nothing called as a Gyanvapi Mosque in any Islamic text. There is no word called Gyanvapi in any Islamic text. So that is not a mosque at all. A temple which was already existing has been converted or has been tried to be given a shape of a mosque, but the deities are still existing at the same very place. Lord Ganesha, Lord Hanuman, Ma Shingar Gauri, visible and invisible deities are existing at the same very spot, and therefore we had asked for a ASI survey of the premises in question, because there was a survey conducted by the Advocate Commission on 6th and 7th of May, on 14th, 15th and 16th of May 2022, and in that commission, lot of signs of Hindu religion and Hindu temples were found during the survey. And to buttress our submission, ASI survey was the need of the hour, and the Honorable District Court of Varanasi has ordered the ASI survey on 21st of July. The Honorable Allahabad High Court has ordered the ASI survey on 3rd of August 2023, and the Honorable Supreme Court has also affirmed both the orders by virtue of its order dated 4th of August 2023. So now the factual position is that ASI survey is going on. Ground penetrating radar and other modern techniques are being used to ascertain that whether the so-called structure which is standing in front of us is a structure of a Hindu temple or it's a structure of Islamic architecture, whether it was built by Aurangzeb or whether this structure dates back to Aurangzeb is the main zone of consideration for the ASI. And as of now, there is a gag order by the Honorable District Court of Varanasi as to speak on what is happening in the ASI survey. So in that portion, I won't dwell. But I can only tell you that yesterday the Honorable District Court Varanasi had extended the ASI survey to 4 weeks. And after 4 weeks, the ASI will submit a report. The Honorable District Court has directed the ASI to submit a report by 6th of October. So we are hopeful that ASI will complete its work and will submit a report by 6th of October. But let me also tell you that all these surveys are happening through non-invasive methods without causing any damage to the structure.
Okay. Sir, we came to know that some of the Hindu symbols are found over there, like lotus and Trishul. Many kinds of symbols are found over there. So how significant this place to the Hindu society, sir? Because many people doesn't know the significance of this place. What is it all about and so and so. How significant is this place to the Hindu society, sir?
You have asked a very good question, and let me answer it in a little detail. See, the fact of the matter is that the temple where we are worshipping in Kashi Vishwanath is a temple which was built by Rani Ahilyabai Holkar in 1770. It was built by Rani Ahilyabai Holkar in 1770. So when Aurangzeb demolished the temple, partially demolished the temple in 1669, there was already a temple which was existing at this very place, which has been given or converted into a shape of a mosque, and which is no mosque as per Islamic law and as per Hindu law. Now this place is very, very important to us because, as I have told you, Lord Shiva had self-incarnated himself in Swayambhu form in this very place. So this place is very, very sacred to us because as per Hindu Shastric Niyam, when a deity has self-incarnated, that entire sthan, that place itself is full of divinity.
Okay.
So this is an argument of divinity. This entire place where Lord Shiva has self-incarnated himself in Swayambhu form is divine to us, is sacred to us. This entire 5 course area is sacred to us.
Okay.
Therefore, this place is having very, very important, you can say, or I can term it in a different way. हमारे लिए, हम सारे सनातनियों के लिए, it is having a very, very divine importance.
Okay.
And शास्त्रिक महत्व. And apart from divine importance and Shastrik Mahats, it has spiritual importance also. Like if you, because you are from South, if a person in the end of his life, there are many ashrams in Kashi where persons go there and stay there because they believe that from there they will go to Shivlok.
Okay.
So that's the place of Mukti.
Okay, Mukti.
That's the place of Mukti. That's this Jyotirling. Out of 12 Jyotirlings, 5 Jyotirlings are Swayambhu, and out of 5 Swayambhu Jyotirlings, the first Jyotirling is of Adi Visheshwar, which is situated in Kashi Vishwanath.
Okay.
Now we have found a Shivling there. which was there in the Wazoo tank. Now it has to be ascertained by the ASI through modern techniques that what's the length and breadth of the Shivling, because that Shivlingam has been found on the first floor. Now the Anjuman Intizamiya is saying that it is not a Shivlingam, it's a fountain.
Okay.
So all these things have to be decided. But answering your question, the fact of the matter is that where the Lord has self-incarnated himself, that place itself becomes sacred to us.
Okay.
It doesn't matter whether you demolish my temple or you demolish the Shivlingam.
Okay.
We can again, that place itself becomes very important, and Shivling can be again pran pratishthit there, and it can again be worshipped. Because if you demolish a temple, Supreme Court has also mentioned in Ram Mandir judgment in para 116 and 117 2021 SCC page 1 that if you demolish a temple, the existence of the idol does not vanish.
Okay.
The idol will remain there in invisible form, and the moment the deities the moment the devotees get a right, they again establish the idol and they start worshipping. But but till date you have not established an idol, and idol has been demolished or desecrated. It remains there, it is present there in invisible form.
Okay.
So therefore this is the Shastrik Mahatva. This Shastrik Mahatva which I am telling you has been mentioned by B.K. Mukherjee in a famous book of Hindu law. This has been mentioned by P.V. Kane in his Dharm Shastra. It has also been mentioned by Mr. Shastri in his book on Hindu law. So this is the Shastrik Mahatva of a idol or of a Swayambhu Devta. When a Swayambhu is there at a particular place, that place itself becomes divine and sacred to us.
Okay, sir. Sir, we came to know that some of the area has been sealed already over there, and ASI didn't allow the survey over in that place also. Will there be a survey in future courses? Because in some of your debates, I saw that we will appeal to that area as well. So, and will there be a survey in future times? And what is the outcome you are expecting on 6th October, sir?
See, what happened is that when we were doing the advocate commission on 6th and 7th of May and on 14th, 15th and 16th of May 2022, on 16th of May 2022 in the Wazoo tank, we found a Shivlinga. I immediately rushed to the Honorable District Court of Varanasi, and I requested the Honorable District Court of Varanasi to seal this entire area, because the Shivlingam is a very important case property, and it can so happen that when the Muslims come to offer their namaz, and they were offering namaz in heavy numbers, they can demolish the Shivlingam which has been found during the commission survey. So the Honorable District Court of Varanasi on my request sealed that entire area. The Honorable Civil Judge Senior Division at that point of time, Honorable Mr. Justice Ravi Kumar Divakar, he sealed that premises at that very point. And against that order, the Anjuman Intizamiya approached the Supreme Court. Against the order of Civil Judge Senior Division,
Okay.
they approached directly the Supreme Court. The Honorable Supreme Court also affirmed the sealing order and said that the sealing will remain intact, and they transferred the entire trial from Civil Judge Senior Division to District Court Varanasi. After when the Advocate Commission survey got over, I immediately moved an application. First application for ASI survey was of the sealed area.
Okay.
That where Shivlingam has been found in Wazoo tank, that entire Wazoo tank must be investigated by the ASI.
Okay.
That application was rejected by the District Court Varanasi on 14th of October 2022 on the footing and on the premise that if we go for ASI survey of the sealed area, it will violate the orders of the Supreme Court, because the Supreme Court has passed the sealing order. Therefore, we cannot proceed with the ASI survey. Against that order, we went to the Allahabad High Court. Extensive hearing was conducted by Honorable Mr. Justice Arvind Kumar Mishra I of Allahabad High Court, and the Honorable Allahabad High Court on 12th of May 2023 ordered for ASI survey of the sealed area.
Okay.
12th of May 2023, the Allahabad High Court directed the ASI to conduct survey of the sealed area.
Okay.
Against this order, the Anjuman Intizamiya went in as SLP to the Supreme Court, and they were so firm with their belief that it is not a Shivlingam, it's a fountain.
Okay.
And when the Allahabad High Court ordered that it should be ascertained that whether it's a Shivlingam or a fountain through a ASI survey, they approached the Supreme Court against this order.
Okay.
And on 19th of May, which was the last working day of the Supreme Court, they got a stay from the Supreme Court of this ASI survey direction passed by the Allahabad High Court. So I am trying to project before you that Anjuman Intizamiya is saying that it is not a Shivlingam, it's a fountain.
Okay.
But when the actual thing comes about investigation, they say no, it need not be investigated. It's a wrong order, it's a erroneous order. So the fact of the matter is that if one party is saying it's a Shivlingam, the other party is saying it's a fountain, how will it be ascertained?
Got.
It can only be ascertained by a modern technique or by an expert body like ASI. But when ASI has been ordered, they have assailed that order in the Supreme Court. The matter was listed before the Supreme Court on 29th of August. But due to the hearing of Jammu and Kashmir, this Article 370 hearing, the matter could not be taken up because the honorable judges were in the constitution bench. So I am hopeful that in the month of September we will get hearing of this sealed area. I am telling you with a lot of sense of responsibility on your channel that we want ASI survey of the sealed area. We are very firm with our demand, and ASI is already on the spot. If survey is conducted of the sealed area, a consolidated report can be given by the ASI before the district court by 6th of October.
Okay, sir. So if that is not a shivling, as of their language, it is a fountain. Why petition after petition, and how confident you are? Because like I can feel the energy and I can feel how much you are involved in this case as well. So how confident you are about the ASI judgment as well, sir?
See, no one can predict what ASI will say.
Okay.
See, ASI is an independent and expert body, but I am very confident, and let me tell you with lot of sense of responsibility on your channel, that when ASI survey will be conducted, nobody in this world, if people are allowed to go there and visit that spot, nobody in this world can say it's a mosque.
Okay.
This entire area, this Khasra number 9130, is shouting and saying that it's the precincts of a Hindu temple. The western wall of the so-called mosque is a ruins of a Hindu temple. The pillars on which the so-called mosque is standing are the pillars of Hindu temple. The Tehkhana of Vyasji, where Vyas Parivar was worshipping till November 1993, is the place where Hindus were worshipping, and it has all the signs and symbols of Hindu temple. The Tehkhana, which is in possession of Muslims, Anjuman Intizamiya, which is the keys are with Mr. Ejaz. That Tehkhana has all the signs and symbols of Hindu temple. Sanskrit shloks, all the bells, the pillars, everything is of Hindu temple. In Wazu Khana we are finding Shivling. Just near the Wazu Khana there is a well, which is the ancient tradition that Shivling was being there was Abhishekam of the Shivling by the well, by the water of the well. So this entire area is having all the signs and symbols of Hindu temple. Beneath the three central domes, there are shikhars of Hindu mandir. There are swastik chins, there are Trishul, there is Damru, all the signs of Hindu temples are there. So if you enter into a Hindu, see this is, let me just reformulate it. This is a clear case where somebody enters into a Hindu temple, they try to give it a shape of a mosque, and they start offering namaz there.
Okay.
I have told you so many incidents and proofs of Hindu temple. Let me add also that there are travel accounts where travelers have come and seen, Peter Mundi has come and seen that Hindus are worshipping at the site in question. And the water they are offering to the Shivlingam is going to the Ganges. The gazetteers prove this point. The historians ASL Trekar, Rana PB Singh, they have proved this point that even after demolition in 1669, the Hindus used to worship the plinth of the mosque by believing and by having a belief that their deity is situated inside. So there's a book called Banaras Illustrated by the DM of that time. So the point is that we have so many proofs and documents to prove our point. But if you will ask Anjuman Intizamiya that what proof you have, so apart from saying that we are offering namaz in this place from 1669, they have no proof.
Okay.
They don't have enough. Let me tell you with lot of sense of authority that Anjuman Intizamiya has not even a proof of it being a waqf.
Okay.
In Deen Mohammed's case, it was asked that whether Aurangzeb has created it as a waqf.
Okay.
They couldn't show any document, or they couldn't file any document before the honorable court at that point of time also by saying that it's a waqf. So if it is not a waqf, it cannot be a mosque.
Okay.
For a mosque, it is very, very important that you must have it as a waqf property. But it was not dedicated as waqf by Aurangzeb. and it is not waqf by user also.
Okay.
They have no document to show or prove that it's a waqf. So just only saying that we are offering namaz in this temple premises from 1669, they have no proof.
Okay. So
It's a case of no proof.
Okay.
No evidence.
Okay. So you are so confident that it is a temple and how the judgment will come. And sir, is there any constitutional barrier for in this case, sir? Because we have the Places of Worship Act 1991, which allows only the dispute of Ram Janmabhoomi at that time actually. So is there any constitutional dispute for this area, or if the ASI survey or the ASI judgment comes in favor of the Hindu side? So what will be the will there be any constitutional barrier, sir?
See, according to me, that there will be no constitutional barrier. Rather, the constitution permits us to invoke our judicial review remedy. Now, the fact of the matter is that, as I have told you, that till November 1993, we were worshipping in the premises in question. Places of Worship Act has come in 1991. It is the case of violation of Places of Worship Act by Anjuman Intizamiya.
Okay.
Because a Vyas Parivar was worshipping in the cellar in the Tehkhana, which is situated beneath the mosque, at the ground floor of the mosque. How can it be a mosque at all? And who has dispossessed the Vyas Parivar in November 1993 in violation of the Places of Worship Act? Because Places of Worship Act says that there will be status quo of the of any place of worship, and it was enacted in 1991. In violation of section 3 of the Places of Worship Act, the Vyas Parivar was thrown out of the Tehkhana. The idols of Lord Ganesh, Lord Hanuman, visible and invisible deities, and Ma Shringar Gauri, which was worshipped daily, were restricted in November 1993. And let me tell you that Ma Shringar Gauri, which is existing on the western side of the so-called mosque, was being worshipped daily. It was only in November 1993 when Mulayam Singh Yadav was the Chief Minister of Uttar Pradesh. He barricaded that entire area. He stopped the worship of Lord Hanuman, Lord Ganesh, the people tree. The Vyas Parivar was dispossessed from the premises in question. Till today, we are worshipping Ma Shringar Gauri on the western side of the so-called mosque once a year.
Okay.
On the 4th day of Vaishantik Navratra.
Okay.
Earlier, this worship used to happen every day. So, Places of Worship Act is not attracted in this case, and it is not that I am saying this to you on your channel. We have proved it in the court of law.
Okay.
This issue was raised by the Anjuman Intizamiya by way of an application under Order 7 Rule 11. Extensive hearing happened before the Honorable District Court of Varanasi. On 12th of September 2022, the Honorable District Court of Varanasi held that Places of Worship Act is not attracted in this case. The Waqf Act is not attracted in this case. Against that order, Anjuman Intizamiya filed a revision petition before the Honorable Allahabad High Court. Honorable Mr. Justice J.J. Munir had extensive hearing of the matter. 20 hearings were conducted before the Honorable Allahabad High Court. And on 31st of May 2023, the Honorable Allahabad High Court gave a historical verdict by saying and holding that the judgment of the Honorable District Court Varanasi is correct, and this case is not barred by Places of Worship Act 1991 or the Waqf Act 1995.
Okay, sir.
So there is no constitutional barrier.
Okay.
Rather, it's a case of violation of Places of Worship Act. And let me also tell you that Places of Worship Act, in my legal opinion, is completely unconstitutional. We have also challenged the constitutional validity of Places of Worship Act in the Supreme Court. I was the first in the country to challenge the Places of Worship Act before the Honorable Supreme Court. The Honorable Supreme Court has issued notice in the matter. The central government has not filed a reply in that petition till date. But the Places of Worship Act is unconstitutional for a very, very specific reason. That if secularism is the basic structure of the Constitution, the right to have a judicial review and right to approach the court is also the fundamental right and the basic structure of the Constitution.
Got it.
So the Places of Worship Act Section 4 Subclause 2 takes away the rights of judicial review and takes away the rights of Hindu community for approaching the court.
Okay.
So therefore we have challenged on that footing, we have challenged the constitutional validity of Places of Worship Act. But so far as Kashi and Mathura is concerned, it has been held that Places of Worship Act is not attracted in this case at all.
Okay. So is there any chances for this law to be null and void? I mean, this Places of Worship Act, you, as you said, you challenged it in the Supreme Court as well. So what are the chances that it can become null and void, sir?
See, as I am telling you that it's been 1.5 years We have challenged the places of worship and in the Supreme Court. The Supreme Court has issued notice to the central government, and central government has not even filed a reply till date.
Okay.
So there are chances that Parliament may repeal Places of Worship Act on its own, because we do not know the stand of the central government on Places of Worship Act as of now. Apart from that, Places of Worship Act is completely unconstitutional, as I have told you, that it takes away the rights of judicial review remedy, which is available to any citizen in this country. Suppose I demolish a mosque, for example, and I convert it into a temple. The Places of Worship Act, if applied, will say that no, you cannot approach the court and you cannot remedy that wrong.
Okay.
So historical wrong can be remedied, was argued by my senior Mr. Parasaran and my senior Mr. Shankar Jain. In Ram Mandir case, the Honorable Supreme Court in Ram Mandir judgment said that historical wrongs can be remedied by the sovereign.
Okay.
And judiciary is one of the sovereigns. Judiciary is exercising the sovereign functions under the constitution. So if there is a historical wrong which has happened in this country and the citizens want that historical wrong to be remedied through constitutional means, what is the option available to the citizens? What is the constitutional option available to the citizens? They can only approach the court and they can solve the dispute by proving their evidences, by bringing their facts in the knowledge of the Honorable Court, and then they can get a decree from the Honorable Court to remedy that historical wrong. That's the most decent way to do this. So therefore, if you are taking away that right to do this, to even approach the court and even have a trial on these issues, then I think this is the most draconian law which has ever been legislated by any parliament, and I think it will be struck down one day either by the parliament itself or by the Honorable Supreme Court.
Okay, sir. So there is a silent revolution which is happening in the Krishna Janmabhoomi case, because nowadays, I think in one of the meetings in which UPCM is hosting in a web meeting, so one of the person present there also has been asking about the Krishna Janmabhoomi and what is the future course and so. So what is your take on the Krishna Janmabhoomi? And Kashi is ongoing legal battle and Ram Mandir has been done. So what is your take on this Krishna Janmabhoomi, sir?
See, I'll just tell you that we have been the first in this country to research on Krishna Janmabhoomi, and me and my father, we went to the district court of Mathura. We took out the documents which were in very dilapidated condition in the records room of Mathura Civil Court. We got those documents typed and translated, and then we found that this compromise which happened on 12th of October 1968 between Shri Krishna Janmabhoomi Seva Sangh and Shahi Idgah Masjid is completely illegal, void, non-est in the eyes of law, and we challenged that compromise by way of a civil suit by the Devta himself, Shri Krishna Virajman, through Next Friend. We filed the civil suit before the civil court of Mathura in 2020. On 25th of September 2020, we filed the civil suit. Then when we were participating in the proceedings in Mathura Civil Court, we found that the proceedings and the proceedings in Mathura Civil Court are very slow. The functioning of the civil court is very slow. Seeing the importance of the matter, we filed a transfer petition before the Honorable Allahabad High Court.
Okay.
In CPC, there is a provision that if any matter is of substantial question of law and it's of national importance, then you can approach the Honorable Allahabad High Court. You can approach the High Court for transferring the entire trial to the Allahabad High Court. In Ram Mandir case also, the Honorable Allahabad High Court had exercised its powers under the CPC and transferred the original trial to itself. In 1989, the trial was transferred from Faizabad Court to Allahabad High Court for original trial. Okay. So we argued before the Honorable Allahabad High Court that this matter is of national importance and therefore the original trial must happen before the Allahabad High Court. The Honorable Allahabad High Court accepted our request. The Honorable Single Judge of the Allahabad High Court accepted our request, and on 26th of May 2023, all the matters pertaining to Shri Krishna Janmabhoomi, all the civil suits which were filed before the civil court of Mathura and which were pending before the civil court of Mathura were directed to be transferred to the Allahabad High Court for original trial. Against that order, the Shahi Idgah Masjid went in appeal before the Honorable Supreme Court.
Okay.
The matter came up for hearing before a bench of Honorable Mr. Justice Sanjay Kishan Kaul and Honorable Mr. Justice Sudhanshu Dhulia. And when the matter was argued by Shahi Idgah Masjid, the Honorable Supreme Court observed that it's a completely right and justified order, and these kind of matters must be tried by the Honorable High Court at the original instance, and this order is perfectly valid and right. They have also called a report from the registrar of the Allahabad High Court as to how many cases have been filed, because once we filed the case, after we filing the case, many of the parties there, they copy pasted our suit and many suits were filed.
Okay.
So they have asked for a report from the registrar of the High Court as to how many suits are pending in the civil court of Mathura, and they will bifurcate as to those suits which are having multiplicity of proceedings in nature, and they will bifurcate those suits, and those suits only which have original pleadings and which are not copy pasted, those suits will only be transferred to the Allahabad High Court for original trial.
Yeah.
So I feel and I hope that once the matter is finally settled by the Honorable Supreme Court as to how many suits will be tried before the Honorable Allahabad High Court, then very soon we will see lot of development in Shri Krishna Janmabhoomi case. It's our commitment, it's our research. We have come up with this research that 12th of October 1968 compromise is illegal, and therefore I believe and I feel that Shri Krishna Janmabhoomi case is a very very strong case. It is not barred by Places of Worship Act or Waqf Act, and we have lot of historical records, research, travel accounts, gazetteers to prove that we were worshipping in that place from time immemorial. Lord Shri Krishna was born there, and if ASI survey is conducted, the Karagar of Kans, where Lord Krishna was born, will be found there.
Okay.
It will be found there where this so-called mosque is being
Built over
there. So all these things will happen in some future. We are just waiting for the clearance by the Honorable Supreme Court, and that hearing is also likely to commence in the month of September. Once we are cleared by the Honorable Supreme Court, the original trial will start before the Honorable Allahabad High Court, and then all the applications, appropriate applications will file before the Honorable Allahabad High Court.
Okay, sir. Sir, just a small question. Is there any challenges from the Hindu side or to your side in claiming the Krishna Janmabhoomi, sir?
See, very interestingly, the Shri Krishna Janmabhoomi Trust, which was not signatory to that compromise on 12th of October,
Okay.
they have also filed a suit in support of our case.
Very
And they have said that yes, whatever Mr. Vishnu Shankar Jain is saying and his father is saying is completely correct. And this compromise is a forged document. This compromise is null and void, and it is not a compromise in the eyes of law, because the fact of the matter is that in 1815, Raja Patnimal of Banaras had purchased this entire 13.37 acres of land, which is very sacred to the Hindu community, from the British government in auction purchase.
Okay.
And ultimately the heirs of Raja Patnimal gave this entire property to Shri Krishna Janmabhoomi Trust.
Okay.
And this compromise happened by Shri Krishna Janmabhoomi Seva Sangh, which is a very like the names are very similar, Shri Krishna Janmabhoomi Seva Sangh and Shri Krishna Janmabhoomi Trust. But the original owner of this property is Shri Krishna Janmabhoomi Trust.
Okay.
Now Trust did not enter into any compromise. Trust did not sign any documents with Shahi Idgah Masjid. So if Shri Krishna Janmabhoomi Seva Sangh has signed any compromise or document with the Shahi Idgah Masjid, how will it be binding on the original owner? And that's the entire gimmicks of this entire case. The entire case revolves around this compromise. If 12th of October compromise 1968 is declared as null and void by the Honorable Court, which will happen because there is no answer to this point. Let me tell you, as a lawyer, I'm saying, even if you play as a devil's advocate, if Shri Krishna Janmabhoomi Trust has not signed the compromise, who's the original owner of the property, this compromise is not binding on us. Okay. Is not binding on the devotees, it's not binding on the original owner. So there is a very famous movie which came in Hindi cinema. It was known as Bunty and Bubbly,
Okay.
where two fraudsters had sold Taj Mahal. So something like this has happened in this case.
Okay.
The people who are not the original owners of the property, they have sold the property. They have entered into a compromise. So therefore, I believe that it's a very, very strong case. The research, which was very crucial, we have done that research. This point has now been floated before the world. to think over and ponder, and we will definitely argue this matter before the Honorable High Court.
Okay, sir. Sir, right from your starting of your practice, you have been a strong advocate for this Ram Mandir issue. Right from 2010 or 12, you are handling this issue, and you and your father has been battling for the very long time, right from 2010. So, where are the twists and turns which has happened throughout your this judgment, sir?
See, when I was born in Lucknow, and my mother is from Faizabad, so I have been born in amidst and in surrounding those slogans where everyone used to chant those slogans, बच्चा बच्चा राम का जन्मभूमि के काम का, सौगंध राम की खाते हैं मंदिर वहीं बनाएंगे. These were the slogans. Between these slogans I was born, and right from my childhood days I've seen my father took up the issue of Ram Mandir in 1989, when the matter travelled to the Honorable Allahabad High Court. From 1989 till 2019 he continuously fought for Ram Mandir case, and he offered his services free of cost pro bono in favor of Ram Mandir. So I have seen this entire case from the very beginning, and by God's grace, when I passed out my law in 2010, I passed out my law in July 2010. That time Ram Mandir hearing was at its peak before the Honorable Allahabad High Court. So my first wakalatnama of my legal profession was in Ram Mandir's case. When I became the advocate on record in the Supreme Court in 2017, my first wakalatnama I filed was in Ram Mandir case. So this is my attachment with the issue and the so-called cause. And now coming to your question that what is the twist and turn in Ram Mandir case, I feel that Ram Mandir case was a very clear case. That structure itself was having all the characteristics of a Hindu mandir. There were 14 kasauti ke pillars which were found during excavation in Ram Mandir case, and on those pillars only the so-called Babri Mosque was standing. In the so-called Babri Mosque there was idol of Hanumanji. There was idol of Vara Devta which can never be in the so-called mosque. There were cellular shrines which is a Shivlingam. So there was lot of historical evidences of Aine Akbari in 1592, where the courtmaster of Akbar himself had written that in Ram Court people used to go and worship and offer worship and prayers at Ram Navami, and they used to have parikrama in this entire area. So this Ram Mandir case was having lot of historical evidences. Gazetteers were there, travel accounts were there, Buchanan had come, French travelers had come, Munichi has come. There were a lot of travelers who had seen that worship was going on. In fact, let me also tell you that in 1510, Guru Nanak Dev had visited that site in question. He had a bath in Saryu river and he offered his worship in Ram temple. In 1510, it is mentioned in Guru Sakhi, and it was quoted during the hearing of Ram Mandir case. So there was continuous worship before demolition and after demolition in Ram Mandir case. And it is only in 1855 when the British government put a railing there and they divided that property and they allowed the Muslims to offer namaz there, and they allowed the Hindus to offer their worship outside in the Chabutra. It is at that time when the dispute started. From 1528, which is the alleged date of demolition by Babur, till 1855, let me tell you with lot of sense of responsibility, the Masjid Committee, the Sunni Central Waqf Board had no proof, no document to show that from 1528 till 1855 they were having any namaz also there.
Okay.
No proof from 1528 after demolition, after the so-called demolition by Babur till 1855, the Muslims had no proof to show that they were worshipping in the premises in question. It is only in 1855 when the British government, with their policy of divide and rule, they entered into our temple, they put a railing there and they divided that property, and they asked the Hindus to offer their worship on the Chabutra, and they asked the Muslims to offer namaz inside the so-called central dome. So it is at that point of time the dispute started. The Nirmohi Akhada was the first to file their suit. Then Gopal Singh Visharad filed its suit. Then Devki Nandan Agarwal filed a suit through Ramlala Virajman, and ultimately the suit of Devki Nandan Agarwal through Ramlala Virajman was decreed. The entire property was given to the deity. A trust was created by the parliament. So I think it's been a very long legal battle, and it's a legal battle which shows and which proves that historical wrongs can be remedied. The Honorable Allahabad High Court, the lengthy judgment passed by the Honorable Allahabad High Court, when the operative portion was passed, it was a little demoralizing for all of us, because this entire land we believed is the land of the deity. And when you are dismissing the suit of Sunni Central Waqf Board, how can you give them one third? So we had filed an appeal before the Honorable Supreme Court, challenging the order of the Allahabad High Court delivered on 30th of September 2010, and we stated before the Honorable Supreme Court, when the suit of Sunni Central Waqf Board has been dismissed, how one third can be given to Sunni Central Waqf Board. And the matter was argued by before the Honorable Supreme Court, which is the second largest hearing after Keshavananda Bharti. For 42 days the hearing happened before the Honorable Supreme Court. Lot of historical records and everything to prove our case was stated before the Honorable Supreme Court, and it's a first appeal from the order of the Allahabad High Court, and the matter has been ultimately decided by the Honorable Supreme Court in November 2019. So I feel that there were a lot of twists and turns in Ram Mandir case. When the matter was argued before the Allahabad High Court, one of the sitting judges of the Allahabad High Court said that there was a lot of pressure at that point of time upon him.
Okay.
He has come out on the media and he has said that. So I don't know what's the reason for the Allahabad High Court to grant one third, because we had argued the matter before the Allahabad High Court. It was a very, very clear case, and despite that one third, the property was divided into three parts, and against that we went to the Honorable Supreme Court, and ultimately the Honorable Supreme Court has granted that entire area as a land belonging to Ramlala Virajman.
Okay, sir. Sir, tell us about your association with your father, because like we saw a meme, both of you were wearing the advocate's coat, and they said that even black coat wearing people will be seen as hero. So both they referred you both people as well. So how do you draw the source of inspiration from your father? And we came to know that you helped him in drafting this legal applications as well. So tell us your association with your father, sir.
See, I have become a lawyer only because of my father. My father, Mr. Shankar Jain, is a role model for me, and he is a true inspiration for me and for many people in this country and around the world, because of a very, very sheer reason that he has. And I'm just saying this not because he's my father. I'm saying because as a third person also I've seen him. The commitment which he has for protection of Sanatan Dharma is unparalleled and unmatched. See, in 1989, when he was entering into Ram Mandir case, there were a lot of offers given to him by Sunni Central Waqf Board to join their side and to argue on their behalf. But he chose not to argue on their behalf, and he chose to give his selfless service for Ramlala Virajman. He has never given any importance to money. He has never given any importance to any power or pelf of the post. He has always given importance to real issues which are affecting the Sanatanis and which are beneficial to the Sanatanis, which will give benefits to the Sanatanis. He has always devoted his selfless service for the Sanatanis. He has completed 47 years of legal practice, and let me tell you, he was enrolled in 1976. In August 1976 he was enrolled. From 1976 till this very day, while I am talking to you, every day, every minute, he is working for the cause of Sanatanis. Every day, every minute. So he has been my role model, and I have become a lawyer only after seeing him. His arguments in the court, he argued a matter before the Honorable Supreme Court, which is a reported judgment, Harishankar Jain versus Sonia Gandhi. In 2000, in the year 2000, he fought an election against Sonia Gandhi. He lost the election not for winning the election. He fought the election for the purpose of challenging the citizenship of Sonia Gandhi.
Okay.
And he challenged the citizenship of Sonia Gandhi, and he brought it to the knowledge of the Honorable Supreme Court that Sonia Gandhi is an outsider. Her real name is Antonio Maino, and this practice of marrying Section 5C of the Indian Citizenship Act must be declared as unconstitutional. And I saw the level of arguments by my father. He argued before the bench of Justice Lahoti in 2000, and I was sitting in the galleries of the Honorable Supreme Court. He said that, "My lord, I am not here to ask anything for myself." I still remember his sentence. He said that, "My lords, I am not here to ask anything for myself. I am present before my lords to ask this very simple question, and to bring to the knowledge of this honorable court a very, very simple question, that there can be a situation one day that when Benazir Bhutto will marry somebody in this country, she will get citizenship of this country. She will fight elections in this country, and then ultimately one day Benazir Bhutto will become the Prime Minister of India, and she will give Kashmir to Pakistan. And at that point of time, it will be asked by the citizens of this country that why did judiciary did not take correct step at the correct point of time." So this he argued before the Honorable Supreme Court. He said that, "I am not here to ask anything for myself, but this floodgates which have been opened to the foreigners to come to this country and get citizenship by way of marriage must be declared as unconstitutional." And he drew a distinction between citizen of India and Indian citizen.
Okay.
Like for example, Adnan Sami, he takes citizenship of this country, he will never be citizen of India. He will be Indian citizen.
Okay.
There's a distinction between citizen of India and Indian citizen. The people who are born here, who are son of soil, they are citizens of India. But those who acquire citizenship, they are never citizens of India, they are Indian citizens.
Okay.
And the Honorable Supreme Court in that judgment said that we appreciate the forensic ability of the learned lawyer, but all the points he won before the Honorable Supreme Court, and the only argument of the Attorney General at that point of time was that whatever Mr. Jain is saying is right, but kindly do not decide this case at this point of time, because there will be political havoc.
Okay.
So I have seen my father from very beginning. He has always, every day he has devoted his services to the Sanatan Dharma and Sanatan cause and he is a true Karma Yogi. He is not into profile building. He is not into, you will never see him anywhere in like so much, but he just keeps on working for his cause, for his community, for his principles. He fought for Ram Mandir case. In first time in the Indian legal history, Haj subsidy was banned on his petition in 2007.
Okay.
Honorable Mr. Justice Oak stayed the Haj subsidy which was given to the Muslims. Then in 2013 he filed a case for Tile Wali Masjid when he was on his deathbed. He had an asthmatic attack. Then he fought for Krishna Janmabhoomi, Ram Mandir case, then Kashi Vishwanath case, and our Bhoshala. So many cases he has filed. There is n number of cases which he has filed for Hindu community, which are buried and dusted in the history. And I think I must just say that he always tells me a poem that so many flowers are born to blush unseen and waste its sweetness in the desert air. So I told him that, Father, your sweetness will not be wasted in the desert air, and I will see to it that the Sanatanis know about you. They know about the challenges which you have made for the Sanatani cause, and the purpose is not just to know, to motivate the youngsters that this is the way you can help the cause. This is the way you can, because this is a civilizational battle. This is the way you can you can fight this civilizational battle through constitutional methods. And truly, I think he's a role model for me, and I think for many of us.
Sure, sir. Sir, tell us a short insight about your case registration against the AIMIM registration of the party as well. Because you have registered a case against Asaduddin Owaisi. What is it all about, sir?
See, I have filed a case against AIMIM because if someone will read the constitution of All India Majlis-e Muslimin, AIMIM party, you will find that the entire party is being created or formulated for promoting the cause of Muslims. Now it is very, very hilarious that you give a declaration under section 29B A and B of the Representation of People Act that you will abide by the principles of secularism and socialism. So on the one hand you give this declaration, on the other hand the constitution of this entire party constitution, if you will see their objects, is to promote all the sections of Muslim community. They want reservation for the Muslim community, they want a special treatment for the Muslim, everything is for the Muslim community. So you want to go into elections for promoting a cause only for Muslim community, which is not permissible under the secular constitution, which is not permissible when you give a self declaration that you will abide by the principles of secularism and socialism. So therefore I had challenged the constitution of AIMIM, and there is no provision under the RP Act that the election commission, after recognizing a party, can de-recognize a party.
Okay.
That power is only with the High Court.
Okay.
So therefore I had filed a petition before the Delhi High Court. From past 5 years the AIMIM has not even filed a reply to that petition. The notice has been issued in my petition, but till date they have not even filed a reply.
Okay, sir. Sir, the next big thing or the next big debate is the UCC, and there has been a debate in and there about the UCC, how it will be and how it will reflect the society as well. And you recently said that UCC is a hoax as well. So, what is your take on the UCC, sir? Because government is planning as the next big thing, or the election manifesto or the election weapon as the UCC one. So, what is your take on the UCC, sir?
See, I'll again repeat my statement that UCC is a hoax.
Okay.
I'm still sticking to that statement. But if the government is pondering and dwelling upon bringing UCC, then there are certain things. The first argument is that, according to me, it is not our duty to correct someone's house. If there is a problem in someone's house, they themselves can correct it. But if we are dwelling into having the corrections in someone's house, then definitely I feel, when that's the second limb of the argument, then definitely it's a women justice issue, it's a gender justice issue, it's a women dignity issue, and there are certain areas where uniformity is required. The first area is that number of marriages. If a Hindu has more than one marriage, it is punishable under section 494 of the IPC. But a Mohammedan or a Muslim, he does not get punished under section 494 of the IPC. The basic theme of criminal law is that it will be uniform for all. But when it comes to marriage, it is punishable for one section of the society and it is not punishable for the other section of the society. So first, uniformity needs to be in the IPC, when section 494 has to be made uniform for everyone. That is point number one, number of marriage. The second area of uniformity where I feel that this law must be brought in is the age of marriage.
Okay.
If you know that the Child Marriage Prohibition Act is very much applicable to the Hindus. We can't marry anyone below the age of 18 years. But there are various sections of the society and various communities who are practicing various different religions. They can marry any person below the age of 18 years. And the Kerala High Court was seized of this matter, and there was a very brutal rape case which happened in Kerala, and the Kerala High Court was shocked with this argument that they are taking a plea that they do not come within the purview of POSCO Act. So such heinous crimes like POSCO Act are not applicable to one section of the society, because they say that they can marry at any age, or at the not any age, they can marry after the age of 9 years. So I think that the number of marriage and age of marriage are the two areas where uniformity is required. And then apart from that, there are various practices which are very regressive in nature, like halala muta marriage, female genital mutilation. This is a practice which must be completely stopped. So these are the areas where I feel that uniformity must be brought in, and if it is brought, then definitely it's a women dignity issue and a gender justice issue.
Okay, sir. Sir, there is a Shariat law, and there is other thing which, if UCC is brought in, what will be the Shariat course of these Shariat laws? Sir? Will it be null and void, or what is the implications of the other religions? Because nowadays, yes, sir.
See, let me tell you, when uniform civil code we are talking about, we are only seeking uniformity in certain areas.
Okay.
We are not going to suppose someone is having marriage through nikah process, which is a contract for them, or Christians are having their own customs of marrying, Parsis are having their own customs of marriage, Hindus are having their own customs of marriage. So there cannot be any uniformity so far as customary law is concerned.
Got it.
But where the customary law is affecting the society in general, where any law is against the public order, health and morality, which is within the domain of Article 25. Article 25 also says that you have a right to religion subject to public order, health and morality.
Okay.
So if you are having female genital mutilation, if you are having muta marriage, if you are having halala, if you are having more than one wife, so these are the, if you are having wives which are less than 18 years of age, so these are the areas where uniformity is required, because this is against public health, law and order and morality, and therefore we are seeking uniformity in these areas.
Okay, sir. Sir, what will be the future course of action? Because like already the Christian groups and Muslim groups have started protesting against the UCC as well. So if it is passed, the government will go according to their wishes, or will it be affecting both the religions, sir?
See, according to me, that there is no question of any protest. See, Christians are hardly affected by this, because if you will see, as per the Indian Divorce Act also, if a Christian wants to take a divorce, he has a mandatory waiting period of 2 years, which is not feasible in today's time. So there are many areas where uniformity is required, where like a ground that irretrievable breakdown of marriage is also a ground for divorce. Then the women, the daughters, they must get equal shares in the property. These are the areas where uniformity is required. So if someone is protesting against a genuine demand, so they are very well to protest, but ultimately the fact of the matter is that the parliament has to pass a law, and the parliament, after considering the report of the law commission, after taking suggestions from various sections of the society, will pass a law, and then ultimately everyone is free that if that law is incorrect or against the constitution, then they can challenge it before the honorable Allahabad High Court, or before any high court in this country. They can challenge it before the honorable Supreme Court.
Okay, sir. Sir, you have also challenged the constitutionality of the Waqf Board Act as well. So, what is this Waqf Board all about, and will it become null and void? Because I come from Tamil Nadu, and where the Waqf Board occupies more areas in temple premises as such, because the land of Hindus have been occupied by the Waqf Board. So, what is your take on that, sir?
See, I've been speaking on the Waqf Board from 2018, and I was trying to, like, it's a duty of a whistleblower. I was trying to tell the society that this is the most draconian law which is going to impact you, and it came into light, my conversations, when this Tamil Nadu incident happened, when a temple which was existing there was declared as a Waqf property, which temple was before coming into force of Islam also. When Islam had come into existence, before the existence of Islam, that temple was existing.
Exactly.
And that temple itself was declared as Waqf property. So Waqf Act 1995 is completely draconian, and let me tell you certain provisions of Waqf Act 1995. Section 4, 5 and 6. A survey is conducted of the Waqf property. The question is that whether there is any survey which is conducted of properties of Hindu temple, of Hindu mandirs, of Hindus, to calculate that how many properties Hindus have attained in the span of 10 years. Okay. According to me, and I've asked this question on national television from so many legal luminaries, no act, no rule, no government order, no law, no bylaw, no notification has any provision as parallel to section 4, 5 and 6 of the Waqf Act 1995. There is no survey of the Hindu properties, but a survey is conducted by the state government for the Waqf properties. And let me tell you, by virtue of section 8 of Waqf Act 1995, the cost of that survey is borne by the state government. which is in clear violation of Article 27 of the Constitution of India, because you are promoting a particular religion by taxpayers' money. Then apart from that, the most draconian provision in Waqf Act is Section 40 subclause 1 and Section 40 subclause 3, which says that the Waqf board can declare any property as Waqf property. Even a property of a trust or society can be declared as Waqf property, and whose property will be declared as Waqf property, no notices will be given to them. So Section 40 subclause 1 and Section 40 subclause 3 is a completely draconian provision. You have not given powers like Section 40 subclause 1 and 43 to any member of the Hindu community.
Okay.
Do you have the power to declare any property as a Hindu community property?
No.
So this power is given to Waqf board.
Okay.
And the person whose property is declared, they will not be served with a copy of this notice.
Got it.
And ultimately, that's why the Waqf is the third largest owner of the land in this country.
Okay.
After defense and railway, the Waqf board is having the third largest ownership of land in this country, because so many properties in this country have been usurped by the Waqf board. Then after that, if someone acquires our property or encroaches our property, the right we have is to go to a civil court and fight a long legal battle and get him ousted from our property and remove that encroachment. But do you know, if Waqf property is encroached, under Section 53 and 54 of the Waqf Act 1995, they can issue a direction to the state government, to the DM and SSP, to remove that encroachment and submit a report to them.
Okay.
Which is unheard of in this secular constitution. Apart from that, there is a special Waqf tribunal which is created under Section 83 and 85. If there is any dispute between a non-Muslim and a Muslim, we are bound to go to the Waqf tribunal under Section 85, and Waqf tribunal constitutes of a member of Islamic law who are known of Islamic law. So you are sending me to a Sharia court. Apart from that, Waqf Act has given all the ingredients of a parallel government, because under Section 80 of the CPC, if I want to file a case against the government, I have to give a notice of 2 months prior notice to the government. Same provision is there for the Waqf board. If you want to file a case against the Waqf board, just like parallel government, you have to give them notice of 2 months and inform them that, boss, we are going to file a case against you. Same provision, like it is a pari materia provision with Section 80 of the CPC. Then the members of the Waqf board are declared as public servants under Section 101 of the Waqf Act. No priest, Pandit, Mahan, Shankaracharya, Pithadishwar, Mandaleshwar has been declared ever as public servant by this constitution or by any act or notification. But the Waqf board members are declared as public servants. So the fact is, if you touch them, it's an offence under the IPC. Then under Section 107 of the Waqf Act 1995, they have completely exempted from Limitation Act 1963. It means that any time the Waqf board can say that any property is Waqf property, as Tamil Nadu incident has happened, as Taj Mahal incident has happened. Let me tell you that Taj Mahal was declared as Waqf property in 2005 by Sunni Central Waqf Board. Taj Mahal was declared as Waqf property by Sunni Central Waqf Board in 2005. They realized in 2005 that this Taj Mahal is a Waqf property, and ASI is in appeal in the Supreme Court and saying that, and Supreme Court is asking them that please show the documents of Waqf.
Okay.
This incidents of Waqf we have faced in Kashi and Mathura also.
Okay.
So for us, for Hindus, the law is that if you want to come to the court, there is a particular time period. You have to come within 3 years or 12 years maximum.
Got it.
That's the limitation period. But for Waqf board, there is no limitation. At any point of time, you can come and say that this is Waqf property and you are exempted from Limitation Act 1963.
Okay.
Then last submission on Waqf Act, the refugees, when our country was divided, many people who migrated Pakistan to Bharat, many people migrated from Pakistan to Bharat, they were they were residing in various properties which were belonging to Muslims. Rajiv Gandhi government in 1984 brought an amendment in the Waqf Act 1954 by virtue of Section 66H, and they gave this entire property where Hindus were residing as tenants to the Waqf board. Ultimately, the custodian of that property was the central government. So the central government being the custodian of the property, ultimately the Hindus were believing that that property will be given to them, and from tenants they will become owners. Ultimately, it led to worst. They became the tenants of Waqf. ultimate, and Waqf used to charge them very meager amount as rent, and now the rent has been increased to 1 lakh 2 lakh rupees, and now the Hindus are having in a very, they are in a very pitiable condition in Punjab or Haryana and rest of the country. Rent has increased to 1 lakh and 2 lakhs as per the latest Waqf rules. And the question is this, that the people who were the tenants, who were to become the owners of the property from the custodian gave that property which belonged to the taxpayers to Waqf board.
Okay.
Ultimately, I am saying that ultimately the central government could have taken the rent from the Hindus, but instead of that, Rajiv Gandhi government brought section 66H and gave that entire property to the Waqf board. And that provision you will find, that is pari materia provision in section 108 of the Waqf Act. The entire property which was within the administration of Evacuee Property Act 1950 has been given to Waqf board. So these are the draconian provisions of Waqf Act, and I have challenged the constitutional validity of Waqf Act in Allahabad High Court, in Punjab and Haryana High Court. There are many petitions which are challenged, which have challenged the Waqf Act in various parts of the country, and I think one day the draconian provisions of Waqf Act 1995 will be struck down.
Okay, sir. Sir, what is your concept of Hindu Rashtra, or are you a strong supporter of Hindu Rashtra, sir?
Yes, definitely. I am a very, very strong supporter of Hindu Rashtra. This country was divided on communal lines. It's a very big mockery that those who were elected on the basis of communal electorate, they drafted a secular constitution. And when this country has been divided on communal lines and on the basis of the population ratio, particular piece of land has been given to a particular section of the religious minority at that point of time. So the fact of the matter is that this country must be declared as a Hindu Rashtra, and my concept of Hindu Rashtra is Adhyatmic Hindu Rashtra, where there will be justice to all, appeasement to none, where there will be no minority commission ministry, where there will be no scheme like 5,200 crores of schemes for minorities and for floating their educational institutions. My concept of Hindu Rashtra is that there will be no violation of Article 27 of the Constitution of India. There will be no Hajj subsidies will be given. My concept of Hindu Rashtra is that there will be no act like places of worship act, there will be no act like Waqf Act 1995. My concept of Hindu Rashtra is that we will get all the rights to remedy the historical wrongs, and our rich and glorious past which our forefathers had lived in this country, that rich and glorious past will be shown to us. And apart from that, our Shastric and Sanatani Niyams and our Sanskrit and our Ved and Shastra will be taught to everyone in the school, and there will be no argument of violation of secularism. So this country has to be declared as a Hindu Rashtra. This insertment of words secularism and socialism in the constitution in 1976.
Will that be removed from the preamble? Will preamble be amended once again?
Yes, preamble will be amended once again.
Okay.
And the word secularism and socialism has to be removed. The original framers of the constitution had very cautiously not brought that word in the preamble. And let me tell you that preamble is an oath which was taken on 26th day of November 1949. That oath cannot be amended in 1976. It was an oath which was taken on 26th. It's mentioned in the preamble that we on this 26th day of November 1949 do adopt and enact ourselves and give to ourselves this constitution. So how can you amend that oath in 1976? And there was no discussion on the word secularism and socialism. Secularism is the only word which is not defined in the constitution. What kind of socialism we are talking about? That you create commercial courts. We used to tell in our law college days that let there be two courts, one court for the poor and one court for the rich. And now that has actually happened. If you have a commercial dispute which has more than 2 crores of value involved, you go nicely argue in AC courtrooms, pay nice court fees and nicely argue in AC courtrooms. And if you have a lesser dispute, then you fight in normal courts. So actually there is total violation of principles of socialism and secularism, and these two words must be removed and redefined, and this country must be declared as a Hindu Rashtra.
Okay, sir. So what is your message to the Hindu society throughout India, sir?
My message to the Hindu society is that it's time for us to unite. It's time for us to realize our issues It's time for us to fight our civilizational battle through constitutional modes and mediums, and it's time for us to come out of this hoax of the word of secularism which has been created by our rulers in the past.
Okay, sir. Thank you so much, sir, for your wonderful time. It's been a pleasure talking to you, and we are learning a lots and lots of things from you and your father as well. Forever, the Indian society will be grateful to you and your father. Thank you so much, sir.
It's
Thank you
honor
so
to
much.
be.
Thank you, sir.